Good morning, everyone. Thank you for your patience. We're just waiting. We have technical difficulty getting one of our members on Zoom. So as soon as we can get her on, we'll jump on here.
Reno, can you hear us?
Not knowing they weren't on the board.
Can I get a sound check from Reno?
Some bears.
You can hear it.
Audio test from Reno. Audio test from Reno.
We can hear now.
They could do that audio.
We hear you, Reno. Do you hear us?
Yes, we do. Thank you. We appreciate it. I'm going to check Steve's mic also. Thank you.
Check. 1, 2, 3.
Yep, you're good.
Right. Hey, good morning, everyone. Here we are back home. Let's call to order this November 20th, 2025 meeting of the Nevada Cannabis Compliance Board. Call please.
Absolutely, Chair. Vice Chair Durrett,
Here.
Member Merritt,
Present.
Dr. Mazarana,
Present.
General Barry,
Present.
and Chair Guzman Freilich.
Present.
You have a quorum, Chair.
Thank you. Now we'll go on to item number 1, which is the public comment. We don't take the online public comment anymore, but we will take public comment down in the south. We'll also take public comment in the north. I know we've got a lengthy agenda today with a lot of regulations, but if we can hold our comments for the regulation portion of it, you will get a chance to talk about the regulations when we get to item number 8. That will streamline things, but certainly, I mean, you can come up to public comment and say whatever you want. That is your choice, but it would streamline it if we hold off on the public comment for all the regulations when we get to item number 8. And then before we go to the regular public comment, I just wanted to say, I've got a little speech and I'll make it really short. Today is bittersweet for me because it is my final meeting as the chair of the CCB and as a board member. My decision to leave the CCB in order to run a campaign for Nevada Attorney General was not an easy one. Being part of the CCB was not something that happened overnight for me. I chased this long before I even sat in this chair. This wasn't a coincidence. This was a dream realized. And I literally was there for all of the hearings when this board was being created. And I actually started applying at that point at the governor's office before it was even passed. But I wanted to thank Governor Joe Lombardo for the honor of appointing me to this position. It has been the greatest privilege to serve in this role, and I mean that sincerely. I also want to express my sincere gratitude to the executive directors that I've had the pleasure working with, Tyler Klimas and Jimmy Hum. Thanks for your leadership. To the entire team, all the agency chiefs and all of the staff, the entire staff members at CCB, all of the DAGs, thank you for your guidance. Thank you for your counsel. You are the foundation of this organization. You continue to set the standard for what responsible cannabis regulation looks like. So thank you for that. To the cannabis industry, the owners, the operators, attorneys, compliance teams, advocates, employees, and the individuals who have come before this board and continue to come to this board, thank you. I have the deepest respect for the work that you do. Last but not least, thank you to all my fellow board members, past and present. Serving alongside has been an honor. I truly cherish our friendship, and I look forward to the future. I will miss you, and I will miss this. So thank you very much. And with that, we'll go on to public comment in the South. When you come up, if you could just please state your name for the record. Thank you.
Morning Board, Tara Baker, Eco Weed Disposal Solutions. We are a cannabis waste management company located here in Southern Nevada. We can be reached at 702-344-3600. 2393 for any of your cannabis waste needs. Thank you.
Thank you. Additional public comment in the south? Okay, seeing none, we'll go ahead and go to the north.
There's no public comment in the north, Chair.
Okay, thank you very much. Now we'll go ahead and go to the consent agenda. We have, let's see. A and B. A being the consideration of the approval of the October 16th Cannabis Compliance Board meeting minutes. And B is a consideration of approval to extend final inspection deadlines to December 1st, 2026. Do I have a motion for the consent agenda? You are also able to pull out any items that you want to pull out, and we can deal with those individually. Go ahead and do the consent agenda in one motion.
Member Bear. I move to accept the items on the consent agenda category A and all the items on category B.
Member
you.
Mazzarana seconds that.
Okay, we have a first and a second for the approval of the consent agenda. Is there any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Aye. Any opposed? Great, motion carries. Okay, now we're moving on to item number 3 on the agenda. This is a consideration of proposed settlement agreement to resolve disciplinary action. And we have presentation. Okay.
Morning all. For the benefit of the record and by way of introduction, I am Tony Garassi, Senior Deputy Attorney General. I will be presenting the settlement agreement under agenda item 3A in the case of CCB versus Blossom Group, case number 2025-006. The complaint at issue in this settlement agreement follows the CCB's 2024 audit of Blossom's facility, which included evidence of certain violations, including repeat violations from prior audits of the facility. The nature and extent of the repeat violations played a part in termination to recommend and ultimately issue the subject complaint after the 24 audit. As outlined in the complaints, which you guys have approved, cannabis cultivation facility assigned to Clark County jurisdiction does have a history of compliance issues, including a prior complaint resolved via settlement agreement in 2020, as well as 2 subsequent letters of concern stemming from a 2022 CCB audit and a 2023 CCB audit, respectively. The CCB did not file complaints from those 2 prior audits, instead issuing the letters of concerns as warnings. This complaint filed and served in September 3rd, 2025. Allegations include, but not limited to, failure to properly tag cannabis, failure to properly dispose of cannabis waste, failing to comply with seed to sale tracking requirements, failing to timely submit required quarterly reports. Violations of a similar nature of each of these have been observed at prior audits of the facility. Respondent answered the complaint in September of 25 via its corporate representative, Mr. Roshan. Mr. Roshan and the Attorney General's office then proceeded through the disciplinary process and ultimately agreed to a resolution, which is in front of you. In that resolution, respondent admitted to 1 category 3 violation, failing to properly tag cannabis and cannabis product, and 1 category 5 violation for failing to submit quarterly reports timely. Respondent agreed to pay an $8,000 civil penalty, which may be paid in a lump sum or over an 8-month payment period at the respondent's option. And finally, respondent accepted a formal warning for its category 5 violation, which is outlined in paragraph 18 of the settlement agreement, which you have. CCB staff and Attorney General considered both aggravating factors and mitigating factors in reaching this agreement. All of that is outlined in paragraphs 10 and 11 of the agreement, which is in front of you. Based on all of that, counsel for CCB recommends and requests the board approval. I'm available for questions, as is Mr. Roshan. My understanding he will be here.
Any questions from the board members with regard to the item before us on the proposed settlement agreement? Okay, thank you. With that, we'll go ahead and bring it to the board for a motion.
Prepared. In item 3A, Blossom Group LLC, case number 2025-006 be approved.
You have a first, is there a second?
Member Merritt, for the record, I second.
Thank you, Member Merritt. Any discussion on the motion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you. Okay, next on the agenda, we've got a consideration of proposed security interests between licensees and financial institutions. We've got one item under that. You can have the presentation. Thank you.
Good morning, Chair, members of the board. Rachel Branner for the record. Item 4A is a proposed security interest between Vireo Growth, Inc., or Vireo, and several financial institutions. Vireo is a publicly traded company and the parent company to Deep Roots Harvest and Deep Roots Aria, Nevada cannabis licensees. Pursuant to the terms of the loan agreements with East West Bank, Western Alliance Bank, and Chicago Atlantic Credit Advisors, the Deep Roots licenses will be considered collateral against the repayment terms of the loan. Should Vireo default, the parties are aware that a TOI will need to be submitted prior to foreclosing on the licenses. At this time, there are no areas of concern which would prevent the CCB from recommending approval of this security interest. I am available for any questions, and my understanding is Lori Rogich, Brian Pick, John Mazarakis, Maggie McCletchy, Gustav Stickley, and Charles Cobiciero are available to address any questions you may have as well. With that, Chair, I'll turn this item back to you.
Thanks, Chief Brenner. Okay, hi there.
Good morning.
Good morning.
Morning.
Ms. Rogich for Vireo is in the north and I believe wants to address any initial questions.
Okay, thank you very much.
Thank you. Good morning, Madam Chair and members of the board. My name is Lori Rogish on behalf of Vireo Growth, Inc., Deep Roots Harvest, Inc., Deep Roots Aria ACO, Inc., and Chicago Atlantic Admin, LLC. With me today, participating by Zoom, is John Mazarakis. He is the co-executive chairman and chief executive officer of Vireo Growth. Also with us is Peter Sack, managing partner of Chicago Atlantic, Keith Caporo, president and chief executive officer of the Deep Roots entities, and Brian Pick, chief legal officer of the Deep Roots entities. Madam Chair, with your permission, I would like to stop for a moment to ask Maggie McCletchy, who is in Las Vegas, to introduce herself and her clients for the record. Thereafter, I will continue with the presentation.
Thank you, Ms. Rogich. And Madam Chair, Director Hum, and members of the board, thank you for considering this matter today. In addition to me on the Zoom, as Ms. Branner pointed out, we have Gus Stickley, who's lead counsel for East West Bank, who's our client. East West Bank is the agent for the lenders on that loan. Additionally, we have Mr. Charles Corsabero, who is a managing director from East West Bank.
Okay, thank you.
Thank you.
Welcome.
Thank you. We are here today to seek approval of a security interest as set forth in the loan and security agreements between Vireo Growth, the Deep Roots entities, Chicago Atlantic, East West Bank, and Western Alliance Bank, as well as the pledge agreements. As detailed in those agreements, the parties entered into a traditional debt financing arrangement in which the lenders are not planning on converting the debt into equity, and there is no mechanism for such conversion at this time. The remedies are limited to enforcement of the security interest and recovery of the debt through collateral, not equity participation. The licensees retain full operational control. However, in the event of foreclosure or enforcement of a security interest on the cannabis licenses, the parties will first come back for suitability and license transfer approvals from the CCB. These agreements are a continuation of a closing transaction between Vireo Growth and Deep Roots. As always, we notified the CCB immediately, scheduled a conference, followed CCB guidance, and drafted the required documentation demonstrating good faith and regulatory cooperation. And so we appreciate your consideration and we are available for any questions that you may have.
Thank you, Ms. Rogich, and thank you for clarifying. That was my only concern, was not that we hope that on anyone, but in case of a default or foreclosure, just so the parties know that they would have to come back to the board for suitability.
Yes, that is correct.
Thank you for that.
And East West Bank acknowledges that, and they're the agent for the lenders on that loan.
Perfect. Thank you.
Thank you.
Any additional presentations, questions, concerns? Okay. With that, then we'll go ahead and bring it back to the board for deliberation and a vote. But thank you for joining us via Zoom. It's always nice to see all the players. Whether by Zoom or by person, it's always good to see a face. So thank you.
Madam Chair,
Yes.
Member Merritt, for full disclosure, I am an employee of Western Alliance Bank for this particular discussion.
Okay. Member Merritt, is there any relationship with the bank at all whatsoever with the two banks that we're dealing with?
I am an employee of Western Alliance Bank.
Madam Chair, Western Alliance Bank is one of the, Maggie Plecci for the record, Western Alliance Bank is one of the participating lenders on the loan on which East West Bank is the agent.
Okay. Thank you. Member Merritt, will you be, and thank you for your disclosure, will you be abstaining for participation or from a vote?
Had discussion with counsel, and we feel at this time, I don't feel that it's necessary that I abstain from the vote because I am not directly involved with this part of the operation of this financial institution.
Thank you for that disclosure and explanation for the record. Okay, that is noted. And with that, we'll go ahead and bring it to the board for discussion, questions. Okay. Any additional questions?
I wish I could have the attorneys give me like a tutorial on cannabis business financing, but since we have a full agenda, I won't ask them for that, and thank everybody for the clean record on this.
Okay. Any additional questions, concerns, comments from board members? Okay, with that, I'll call for a vote. Or a motion, please.
Member Mazarano makes a motion to approve agenda item 4 with the proposed security interest between the licensee and those financial institutions.
Very second.
We have a first and a second. Any discussion on the motion? Hearing none, all those in favor say aye.
Aye. Aye.
Any opposed? Motion carries. Thank you and good luck.
Thank you,
Thank you very
Madam
much.
Chair.
And thank you very
please-
much to the staff. I apologize, Ms. Rovich. Go ahead.
Thank you. We would be remiss if we did not acknowledge Agent Angela Dean. Thank you, Agent Dean, for your collaboration throughout the process. We greatly appreciate your professionalism and patience. I would also like to thank Madam Chair for your years of service and guiding hand in leading our industry. And it's been a true pleasure, and I wish you the best.
Thank you. Thank you very much for those comments.
And I echo Ms. Rogich's comments. Thank you all very much.
Okay, good luck. Thank you very much. We are now going on to item 5. This is a request for withdrawal transfer of interest.
Good morning again, Chair, members of the board, Rachel Branner for the record. Item 5A is a request to withdraw transfer of interest number 21072. This transfer of interest, or TOI, originally requested for Green Therapeutics, a privately held company, to sell its Nevada cannabis licenses to Australis Capital Incorporated, a Canadian publicly traded company. Unfortunately, as Australis was delisted by the Canadian Stock Exchange and the purchase price was to be remitted in shares, there was not a way for the parties to move forward with completing the transaction. As such, Green Therapeutics has requested a withdrawal of transfer of interest 21072. At this time, CCB staff suggest board approve the requested withdrawal without prejudice. I'm available for any questions, and my understanding is that Duke Fu and Terry Booth are also available to address any questions you may have. With that, Chair, I'll turn this item back to you.
Thank you. Okay, any affirmative presentations from the individuals? If not, we can. Thank you. Yes, please come up and state you made the drive all the way over here. You might as well just.
For the record, I'm Duke Fu, representing Green Therapeutics.
Okay.
Yeah, as it already summarized, we had a initial deal to have Australia's Capital purchase our company. Australia's Capital then has been delisted and is, from what I understand, not in business. So there's no real deal to be done anymore.
Okay. All right. Do we have any questions from the board members? And so let me just ask you, so what happens now?
Well, I think Green Therapeutics continues to operate as it has been. So there's no real change. So nothing's really changed since the beginning. And we're still operating right now.
And are you looking then for other avenues?
I'm always open to things, but currently I am continuing to operate it. And we're trying to make the best of continue to do the things we're doing.
Oh, good. Okay. Well, thank you.
Okay.
Yeah, thanks for coming up here. I'll open it up to the board members if they have any questions. No questions, no concerns? Okay. Thank you. We'll go ahead and vote on this. Okay. Do I have a motion?
Member Barry. Move to accept item 5A. Consideration to approve withdrawal request TOI number 21072.
Thank you. Do we have a second?
Member Mezrana seconds that.
Thank you. Any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries. Okay, motion with our item withdrawn. Thank you so much. All right, we'll go on to item number 6. This is a request for transfer of interest. This is with regards to a True Harmony company.
Good morning again, Rachel Branner for the record. Item 6 consists of 2 transfer of interest or 2I requests. Item A is a request by True Harmony Company to complete an internal transfer of interest to transfer 50% ownership from current sole owner John DeJoria to his sister Micheline DeJoria Hidari, and I apologize if I misspoke the names, for no consideration. Initially, the siblings had planned to apply for the cultivation and production licenses together, though due to travel plans, this was not feasible. If approved, Ms. Haydari plans on being involved at high-level operations, but there will be no change to the day-to-day operations. At this time, there are no areas of concern which would prevent the CCB from recommending approval of the proposed transfer of interest. I'm available for any questions, and my understanding is that John DeJoria, Micheline DeJoria Hidari, Robert Karilko, and Catherine Linneman are available to answer any questions as well. With that, Chair, I'll turn this back to you.
Thank you. Do we have the licensees, applicants on Zoom, or do we have them here in person?
You have John and Bob on Zoom.
Okay, great. Thank you and welcome.
Good morning, CCB board members. I think the matter we have this morning is a very straightforward intra-family, non-cash transfer of interest between siblings for their estate planning. So 50%, we have a managing member, John Anthony DeJoria, who owns 100% of the member units, will be giving 50% non-cash to his elder sister for estate planning upon approval today.
Okay. That does sound like a straight business transaction, and it sounds like Mr. DeJoria, your sister, hello. Okay, now we have everybody on here. Hi there. So this is a sibling business. I'm happy to hear that that you're doing that, and Ms. DeJoria, you want to be involved in your brother's business, and so tell me a little bit about that and what prompted that.
So really, it's just family planning, estate planning purposes. It felt like it made more sense for us to do something together and to, kind of have that other half. Heaven forbid something happens, heaven forbid, for he needs some counsel or some advice. I'm not particularly involved in this operation, but I do run other businesses and we're close siblings. So happy to help in partnership.
Well, that's smart planning. Thank you. And thank you for all of the work that you do, especially with, we get our briefing and the baby to baby work that you do. I appreciate that. Thank you so much for what you do.
Thank you. We're lucky to be able to give back. So I appreciate it as much. Thank you so much for that.
Okay, well then, I'll ask the board members if there are any questions that they have with regard to this transaction, and we're happy to help however we can. I think we've got some feedback, but okay, that stopped. All right. Any questions from board members? Okay, easy enough transaction. Thank you for being here with us. Thank you for coming online. Like I said at the previous item, we really do like seeing the individuals that we license. So thank you for being present.
My pleasure. Thank you.
Okay, with that then, I'll ask for a motion.
Member Mazrana moves to approve agenda item 6A, the transfer of interest from one sibling to the other.
Second.
Any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Motion carries. Thank you. Thank you very much and good luck.
Thank you.
Thank you. Take care. Okay, well, moving right along, we will go on to item B on the transfer of interest. This is Greenway Health Community LLC.
Thank you, Rachel Branner for the record. Item B is a transfer of interest request made by Greenway Health Community to transfer 100% of its ownership in its production license to MMJ Investment Facility LLC, also known as MMJ. MMJ is a privately held Nevada company solely owned by Michael Velian. Mr. Velian is also an existing owner in GBS Nevada Partners, which does business under the trade name ShowGrow. MMJ has also requested a waiver of NCCR 5.110 pursuant to NCCR 5.112. Staff suggests that if the waiver request is approved, it be limited to expire at such time as MMJ's next appearance before the board for TOI. At this time, no areas of concern have been identified which would prevent CCB staff from recommending approval of this transfer of interest. I'm available for any questions, and my understanding is Alicia Ashcraft, Michael Velian, and Daniel Caravetti are also available to address any questions you may have. Thank you.
Good morning. Good morning, Chair Guzman-Freilich, Vice Chair Durrett, members of the board, Alicia Ashcraft, on behalf of the applicant. With me here in the Las Vegas hearing room is Michael Velian of MMJ Investment Facility. And by way of Zoom, Daniel Caravet, who's the owner of Greenway Health, is available as well. Just would like to take a moment to thank Investigator Dana Lauren for her work on this. And Dana, unfortunately, had to go out before this investigation was completed. So I just want to also thank Investigator Maggie Adams, who picked up the ball and carried it across the finish line at the end. We're grateful to them for their work and coordination in getting the application forward. We don't have an affirmative presentation as such. Happy to answer any questions. Fairly straightforward. As Chief Branner mentioned, Michael Velian is new to the cannabis industry. He's been around for a while, involved with ShowGrow. And so his investment and acquisition of this production facility is just to strengthen their already substantial presence in the industry. But again, happy to answer any questions. And as I mentioned, Mr. Velian's with me, Mr. Caravet's on Zoom. Thank you so much.
Thank you. Thank you and welcome. Welcome. Any opening comments, anything that you want to say as well, Mr. Caravat?
No, Madam Chair, we're just, we've been a part of the facility doing business with Mr. Caravet for a while, and he feels like his operations or his efforts are better concerned in a different state. And obviously, we live here. This is our backyard. I've enjoyed a good relationship with the board and with the CCB executive offices. And, we're just looking to continue that. And this is an opportunity to keep everybody employed, keep everybody in the same position, and, just business as usual.
That's great. How many employees do you have?
That's probably a better question for my brother, but I'm going to say 20.
Okay, all right. Okay, thank you. Any questions from the board members? I just want one question that I had with regard to that stipulation order back from January. There was a 2-year probationary period, but it drops off, correct?
Correct. So one of the items in the stipulated settlement for that disciplinary action was that if there were a 100% transfer of interest, those two provisions, the one with respect to the probationary period and certain actions that would occur if reports weren't filed and the need for an independent contractor for compliance, those would fall off. But
okay.
Any other would continue for the normal period under the regulations.
But there was a fee, a fine that's been paid off.
Correct. It was paid in full. There was the option for monthly payments, but it was paid in full and taken care of.
Okay, good. So they just start with a clean slate then.
Correct. There were two things that have been taken care of under that stipulated settlement. And just so you're aware that the buyer, Mr. Villian, is aware of it. One was the payment of the fine. The other was a suspension period. That also has been completed. So anything that needed to be done under that stipulated settlement has been, as an action item, has been completed and taken care of at this time.
Great. Okay, that was my only question. Any other questions from the board? Any questions from Mr. Villian, Mr. Caravat? Nope. Okay. All right, we'll take a motion.
Member Drat, I move to approve the transfer of interest proposed in agenda item 6B, in which Greenway Health Community will transfer ownership to MMJ facility pursuant to TOI number 2500026.
Member Mary, for the record, I second.
Oh, just one quick addition and the approval of the NCCR 5112 waiver.
Yes, and that would include approval of the NCCR 5.112 waiver pursuant to 5.110.
Okay. We have a correction on that motion. And who seconded it? Member Mara, did you second that motion? There was a amendment with regard to the waiver.
Yes, I do second that emotion with the amendment to the waiver.
Perfect. Okay. Thank you. Thank you. We have a motion on the table. Is there any discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion carries. Thank you. Thank you. All right. Good luck.
It won't be made back, so we can skip the petition. We can table that.
Great. Okay. So item 7, which was a petition.
Oh, sorry, we got to close that one out, but yeah. Close out 6 and then 7 we can take it. Close out. Okay. Yep.
Okay. All right. So 7, the petition filed pursuant to NRS 678B 633. We're going to go ahead and table that. And now we'll go on to item 8. And so just really quickly on item 8, we have a lot of regulations, but before we get started, just know that I will be making a motion to postpone to the January 2026 board meeting. These are the sections, and I know it's a little bit confusing, but this whole thing is confusing, but let me clarify here. Because what we're dealing with is we're basically dealing with outdated regulations because we're approving regulations from 2024 that went up to the Legislative Council Bureau and then came back for our approval. But between that, we've had the 2025 legislative session, which changed a bunch of stuff. So now we're kind of working backwards. So we need to look at these outdated regulations and figure out what we're going to approve, what we're not going to approve. And then after that, then we need to work on cleaning up all of the outdated regulations. So if that makes sense. But just so you know, I am going to be making a motion to postpone until the January 2026 board meeting, the sections 61, 63, 65, 66, and 71. These are all items that touch on the ASTM standards. But on the agenda, on the actual agenda, it's regulation I. And it's 61 is number 1, I1, 63 is number 3, 65 is number 5, 66 number 6, 71 is number 11. If everybody follows. Okay. So with that, I'll go ahead and
You go over those one more time.
oh, sure. Okay. So on the LCB regs, there are numbers 61, 63, 65, 66, and 71. On our agenda, they are regulation, it's item number 8, and it's I1, I3, I5, I6, and I11. Okay. But with that, we will go ahead and get Michael, are you gonna speak on this? Okay. So you're gonna speak on this, and then what we'll do is we'll go ahead and open it up to public comment. And then what we'll do is, I'll make the motion to postpone those sections, and then we'll go on to the rest of it, the regulations. That work? Okay, perfect. All right.
All right, now we've gone to agenda item number 8, which again will include a opportunity for public comment. As a reminder, the regulations presented today were approved in the 2024 from the 2023 legislation. So I wouldn't actually call them outdated. I would just say that they're approved from the 2023 legislative session and from a solicitation of input that we did with the entire industry in January of 2024. We did workshops in, I think, February, March, April, and May of 2024. Again, not sure, but I know we held 4 official APA workshops covering all of these regs with the small business impact statements. And again, this was the first time because in 2023 is when we fell under the APA for a regulation process. The CCB will also be holding public workshops on December 2nd and December 4th for the 2025 legislative session. And one we held actually yesterday for AB 157. Sorry, SB 157. And we will probably have another 1 or 2 more workshops on that as well. And that's, we just move to public comment.
Okay. So let's go ahead and have public comment on item 8. And just just state your name for the record and.
Good morning. Lake Martin on behalf of the Nevada Cannabis Association. A bulk of my public comment was related to the sections that you are deciding on today. So I will hold that. We submitted a written comment on those for the record. I did want to bring up section 68 sub 3, which increases the lot size to 20 grams for all sample sizes. We do believe that this is still, it was approved in June 2024, but then in 2025, the legislature passed Senate Bill 157, which took effect on October 1st, which explicitly requires sample sizes to scale with lot size. So adopting, doubling the current sample size, but not increasing the lot size is contrary to legislative intent. The proportional approach was central to SB 157, and we believe that this directly contradicts that. I also wanted to mention, I mentioned in our letter, this is section 81 in the regs, but I don't know which exactly number it is on the agenda, but it has to do with the labeling change regarding listing the cannabinoids in the top 3 terpenes. And our folks asked, most of the products on the shelves today do not contain this information, and there's not a clear time to work through that existing inventory. So either an effective date that is delayed by 12 months or guidance related to that would be helpful.
And we almost always do. We let you run through your old labels before we start, and we will on that as well.
Just wanted to make sure that that clarification existed and was on the record.
Absolutely.
Those are my comments. And again, thank you to the chair for your steady leadership these years. We appreciate your guidance and your service to the industry and the board. Thank you.
Thank you.
I want to make actually one quick comment. I want to apologize to everybody. This was the first time, again, this has been done under the APA process. We probably should have waited an extra month and got these regs out for everybody to review a little longer. Again, these are just updates that the LCB made to the regs to make it, to follow their legalese. That's literally all it was. But I think next time we go through this, we will probably give an additional month of notice for everybody to review and make comments on these next time.
Amanda Connor for the record. First, I know it's been a long process to get here, right? We discussed that it started back in 2023. I think it would be helpful for the industry to clarify if you guys vote to approve these today, the next steps and when they're actually going into effect. Just because, again, it's a new process for everybody.
I would love to give you a time frame. I would. We have no idea.
But the next step is it goes to
LCB.
LCB, correct? Right? So it's not like if it's voted today, it's in effect.
No,
I think that's a helpful comment.
I think it goes back to LCB. The LCB attorneys have to review and make sure our minor changes are fine. And then I believe it goes to the Ledge Commission after that.
Correct. So there's some time still until they take effect, and it's unknown an exact effective date.
Correct.
With that was just a clarification I thought was helpful to put on the record for everyone, that the vote today doesn't mean these changes are in effect, because I think there's some confusion about, all the different versions, or not versions, all the different proposed regs and what's to be followed. So right now they wouldn't be in effect. A couple of clarifications that I had, or comments. One was to follow the same comment that my prior commenter, Lake Martin, made with regards to section 68 and the 20-gram sample. I think that there's some arguments that section should not be adopted given the passage of SB 157 and a discussion of the needing to adopt sample sizes proportionate to the increase in lot size. I also think that there could be an argument that by adopting a 20-gram sample, that the lot size would be eligible to increase without further discussion on it. And I don't think that that was the intent given the proposed regulations that were workshopped yesterday. Separately, in regards to section 54, with regards to third parties advertising delivery, there was a clarification in the prior regulations that said it applied to only advertising, not the delivery service platforms. That has been removed. I don't think the intent is that now the software companies, the licensees used to process their deliveries would have to be approved, but I think that that deletion could raise questions because that was the purpose of that language, was to clarify that the software that's used within the dispensary to process deliveries did not require pre-approval. So I think that clarification to the industry would be helpful on that. And lastly, a final comment. I know there was lots of discussion during the workshops on the imminent health hazard notification. We appreciate the board working with us. I would just request on behalf of the industry that there's another method besides Acela to notify of incident reports, given that there are struggles at times with Acela. And that is all I have. Thank you.
Thanks.
Good morning. Good morning, Madam Chair, members of the board, Director Hum. For the record, I'm Kimberly Maxon Rushton, appearing on behalf of RSR Analytical Laboratories. Appreciate your comments at the beginning, Chair, with respect to removing or tabling for considerations sections 61, 63, 65, 66, and 71. Is that correct? That's correct. Thank you. And I think it's important just to note for the fact that section 61 is really problematic. It came back from LCB with a litany of secondary publications that the labs are required to look at, standards. And I appreciate you tabling that because of the fact that I would respectfully submit that's not good regulatory oversight. Asking labs to look at a plethora of secondary resources, I mean, upwards of, I would say, 7 or 8 different ones that are somewhat voluminous and costly. And then trying to discern from there which specific provisions they're supposed to adhere to or what the expectations of the CCB are relative to those publications. So I think it does warrant further discussion. I'd like to have a workshop on that. I think that the industry would be willing to meet with staff, talk about their expectations relative to those specific publications, and then extrapolate from there what the standards are that you want the licensees to adhere to. And then from there, we'll codify that. And I think that would lead to better regulatory oversight and compliance. I do have a couple of concerns. I think some of the language, as Chief Miles indicated, came back different from the LCB than what was submitted and what we contemplated in 2024. As Amanda indicated, this started in 2023. We had multiple workshops, and then 2024, prior to the legislative blackout, there were standards of regulations that were sent to LCB, and some of them came back, and I would say completely different than what the licensees intended. And if I could, I'd like to start specifically with section 72, and that's the regulation pertaining to NCCR 11.075. Give you a second to get there. So as you recall, in 2024, the lab specifically requested the authority to not have to turn over the certificates of analysis to the cultivators until they were paid. Currently, the regulation requires that within 2 business days of the completion of all the panel of tests, a COA be completed, a certificate of analysis, and that it simultaneously be submitted to both the CCB as well as to the cultivator. That's necessary, or the producer, because that's how they move their product. What was happening, and as you heard testimony on, is the fact that the labs weren't getting paid. So the labs were required to turn over the certificates of analysis, but for the work that they'd done without getting paid, and we requested that that standard be removed. I can't discern from the proposed regs whether or not that standard is in place, because in one section of the proposed regs, it says that the labs are required to turn over the certificates of analysis upon request to the CCB. That doesn't make sense. I mean, they should turn them over immediately upon completion to demonstrate that they have completed that, and then it tracks with the seed to sale in terms of their destruction. But then it also says in another section that the COAs will be posted online. That defeats the purpose. I mean, the point is that you shouldn't ask labs to perform the services and then give the COA so that the cultivators and producers can move the product without being paid. So that regulation I would submit under section 72 needs to be completely revised. And I would strongly encourage you not to approve that today so that we can bring it back and reconcile it consistent with what the language was that was approved by this body in 2024, or at least what the intent was. I also have a concern with respect to section 73, which is 11.085. This deals with fees. And I would respectfully submit that that's contrary to the legislation that was passed in 2023, specific to Senate Bill 195, in that it enumerated a specific section under which the CCB could charge fees, investigation fees for certain acts. And those were specific to applications. This is not an application. This is pursuant to an investigation. So for those reasons, I would again respectfully request that you not approve section 73 and the amendment to 11.085 as it's contrary to the statutory intent behind Senate Bill 195. And I believe, Madam Chair, that concludes my specific comments. Again, thank you for tabling those other matters. We will continue to work with staff with respect to enumerating those specific standards. Again, I think the consistency of the regulations with not only the statutory authority, but also with what the intent is behind those specific standards, the good practices, those make sense. But as you obviously saw in section 61, there's one provision in which the labs are asked to adhere to a regulator's guidelines. I don't understand how that would be applicable to a licensee. So again, I think that that's important to withdraw or to table that and to have further discussion. Happy to answer any questions, but thank you for the opportunity today to present the concerns.
Thank you.
Member Mazzarella would like to just clarify. So you're proposing to have section 72 and 73, which on our agenda are items I, 12, and 13 to be postponed?
That is correct. Everybody does that.
Hi.
Good morning.
Good morning.
My name is Logan Wilson with Jennings and Fulton. My clients who are 374 Labs LLC, G3 Labs LLC, M&A Associates LLC, ERP LLC, NVCan Labs LLC, RSR Analytical Laboratories, EPL Nevada LLC. I represent 7 clients here today. I'm here today, reiterating a lot of the points Adam Fulton's addressed. Adam wasn't able to be here this morning. He's up in San Jose and for the 9th Circuit, so I'm sitting in on his behalf. But I did assist him in preparing the executive summary that my clients and we spent a lot of time submitting that to the board. And I don't want to go through each point because I know those were workshopped and a lot of that's been discussed. But we just urge the board to review all the materials submitted. My clients have addressed various statutory issues, compliance issues, scientific issues, constitutional arguments. There are just a myriad of issues that my clients believe, what came back from the LCB just wasn't what was really intended. And I think the postponement of those sections 61, 63, 65, 66, and 71 are the good first step. My clients would obviously request that everything be postponed and that we continue the workshops that were suggested. I just don't think we're in a position now, or my clients don't believe it's in a position now to be voted on. I think what came back down is just so much different than what was approved prior. And we went through that 160 plus page PDF many times and highlighted certain provisions, and we've addressed those in the executive summary of my clients. These are small business owners. We represent 7 of the 8 testing labs here in the state.
My clients just urge the board to review all the materials. My clients request that this regulation be rejected, and now we go back to the drawing board and kind of work from what was intended with what went out of the LCB. I'd be happy to address any questions you have.
Thank you.
Thank you so much for your time.
Any other comments in the South? Do we have comments in Reno?
No comments up here, Chair.
Okay. All right, did you want to respond to some of these comments?
I'll talk about some, again, under the 23 legislative session, we don't have complete control over the regs anymore. It goes through LCB. LCB is going to make their changes, what they believe is the legal way to list everything. We're going to obviously go back and forth on certain things. I think, I want to say section 61 is the one that I think really messed everybody up. And really, it was, we're going to go back and look at it again. I think that's one of the ones that's going to get pulled off. However, that was just a list of standards that the CCB is adopting that we're going to use in other places in the regs. So if we say, Carrie can give better examples, but if we have a lab testing standard, then we're going to refer to that standard that's listed in 61. 61 isn't meant to be an adoption of all standards, and industry has to follow every one of those standards, because they can't, because a lot of those standards are absolutely conflicting. They really are. So it was not meant to be a, hey, industry, you have to follow every one of these. But again, we're gonna work on that further and try to make it a little clearer. But LCB put that in there. All they did was took out all the standards throughout the regs and put them in one big list, because all those standards are already in the regs in some place or another, or in the older regs, or in the approved 2024 regs that everybody approved in 2024. Carrie, can you please respond to a couple of the comments that Ms. Rushton made?
Which one?
One's in the 70, the one about the
72, 73.
yeah, 72, 73, the last. Because I know we did not take out anything to allow you guys, the labs are definitely allowed to withhold the lab statements for payment. Also, the COAs, again, there was another rule that we now have to file all those COAs online. So all COAs are going to be available to the public. However, again, it's not till after you guys get paid and give us those COAs they're going to go on the website.
All right, Chief Cronkite, for the record, in section 73, which is 11.085, this would be subsection 3. It says if the board requests screening for testing to be conducted pursuant to this section, then the facility that basically is responsible for the investigation or for the violation is the one responsible for making those payments. So this isn't saying that you're being forced to pay each other for services that were not rendered. This is saying that if we say you have to test their product, then that person who's responsible for the investigation or responsible for the product is responsible and required to pay that laboratory for those tests that were conducted under our request. So that's really what this is saying. And I believe it still reads that way.
It is absolutely not bringing back time and effort.
No, it's not bringing back any time and effort fees, investigation fees. It's just saying if there were costs that were accumulated by another licensee for that investigation, then they have to pay that licensee for the costs that were incurred. Of course. Any other ones?
The sample size, briefly, after
So,
yesterday too.
for the sample size, Kara Cronkite for the record, regarding the sample collection of 20 grams, this is not in relation to SB 157. This is language that was workshopped multiple times, as Deputy Director Miles stated. The science showed that 10 grams wasn't truly representative enough of a sample for a 5-pound lot of flour or a 15-pound lot of trim. We had all workshopped and the board approved increasing that number to 20 grams as the minimum for the 5-pound lots of flour, 15-pound lots of trim. Obviously, if these numbers have been changed through SB 157 for lot sizes, however, that still has to be workshopped, and those numbers still have to be workshopped and then approved by the board and then sent to LCB and then determined if they're in alignment with the language in SB 157. So that will come later. We started that workshop yesterday, actually. So that language can still be changed. It's just that the 20 grams would be the minimum as we agreed back in 2024.
Until it gets changed.
Until it gets changed by SB 157 regulation during the workshop.
Who agreed? Yeah, well,
It was workshopped and approved by the board.
24. This 20 was, okay.
That was all gone through every other process, just like all the rest of the language. That was something we submitted to LCB and LCB didn't change that portion.
Okay. Thanks.
Thank you again. For the record, Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of RSR. Chair, in your opening comments with respect to holding off on certain regulations under NCCR 11, I wanted to note the fact, and this is actually a question for Chief Cronkite, if it's acceptable. There was language under section 72 that specifically precludes the labs from retesting, rerunning, retesting, things such as that. And it's highlighted in a different color. So I'm wondering if that was an addition that was just made pursuant to today's adoption. And the other part of it is, Chair, is that same language is in other sections that I believe that we are holding off on deliberating on. So let me just, again, for purposes of the record and clarifications, specifically state.
Green is new. You have the actual page number?
Yes, just one second. It's on page 141. And it specifically states, and if I could read it into the record, a cannabis independent testing laboratory may not retest a lot, production run, or test sample of cannabis or cannabis products or implement internal retesting procedures without the appropriate board approval. I believe that that's in other sections. I do have a concern about it in a request for reconsideration because of the fact that once the testing has been completed and the COA has been submitted, if the lab wants to do internal research and development, they want to look at their calibration of their instrumentation. If they are training a new scientist, why would they not be able to rerun a sample that has already been completed, the COA submitted, as long as they document it properly? That doesn't lend itself to, again, good science. Science allows scientists to look at the product or the whatever they're analyzing and make determinations about it. I understand the importance of not consistently rerunning things to get a certain result. And I understand the importance of having the COA be completed. But I believe when you still got a sample on site before it's destroyed, if you can document the reasons for it, does it necessarily require you to take up the time of a board agent to call and explain this to them and ask for permission? If you can explain it to them afterwards, pursuant to an audit. So I would strongly suggest that that language be removed or at least reconsidered because of the fact that it's not consistent with good scientific standards. But again, just note the fact that it's also on page, it's listed 141 in that section. It's listed again in other sections as well. So just to make sure that it's consistent.
Okay. And I would make it straightforward. I mean, I think Karen could explain this too. We don't care how much time you retest it after the COA has been submitted.
Correct. Yeah, if you wanted a blanket approval for research and development purposes, sorry, this is Chief Cronkite for the record. If your laboratory were to submit a request for research and development to after the COA is completed, just for research purposes and or training purposes, to have the allowance to rerun leftover sample, that's something we could provide a blanket approval for, and you wouldn't have to request each individual time.
I really appreciate this, Chair. And again, I don't want to take up your time, but I think that the dialogue with staff is really important because these are issues of clarification. The labs take their responsibilities obviously very seriously and want to ensure that they comport exactly with what the CCB standards are. So thank you, and Chief, for that.
Thanks for bringing that up. I want to throw in a quick plug of everybody show up at the workshops on December 2nd and the 4th, because we're reopening all the recs. So any recommendations for any changes, you can come in on the 2nd, 4th and make the changes we have put in there are just for ledge and what we think needed to be changed. If industry wants any kind of changes, please come in and recommend.
Thank you. And I think it'll be important for the labs also to take a look at those specific periodicals and the standards. And I think we can come forward too with things that we think would be helpful that, again, we extrapolate from those secondary sources and really have some consistency within the industry.
Great.
Thank you very much.
Amanda Connor for the record, and I actually had a clarification question on something that Ms. Rushton had brought up in her prior comment. The proposed regulations, it's my understanding it's not currently permitted, but the proposed regulations would allow a lab to withhold a COA for non-payment. Is that correct? Not currently allowed, but it is proposed.
I think it's currently allowed. We think we made that change years ago.
Chief Cronkite for the record, we currently have a process in place where we can put that COA on hold through metric while still being compliant with the 2-day notice. However, this change was trying to provide a more straightforward option to where you don't have to provide those COAs if you haven't been paid for the work.
Okay, so I guess current process is it does have to go into metric within 2 days. But there is, if the labs would reach out to the CCB, that discussion can be had about holds.
Correct. The CCB staff can work with metric to hold that COA, even if it's already been uploaded to metric.
But that's not outlined in the regs, but the proposal would be a different process to allow the lab to separately hold it and not upload.
Correct.
Okay.
Yes.
But that is separate from the section where it was discussing, which Kara, I think you clarified, if a CCB requests retest, that's a separate issue.
Yes.
Okay. Thank you.
No, this is good. Remember, we're working with
Okay. I will stay.
My comfort.
Lake Martin, Nevada Cannabis Association. Again, I just want to, on the issue of section 68 sub 3 and the confusion it creates, that is the doubling of the sample size while we are currently workshopping an increase to sample size. This is just practically, whether we're looking at timelines or not, practically confusing for licensees who are at, as soon as this is adopted, going to have to double the sample size and whatever that means and that entails, while also workshopping a sample size that is aligned with Senate Bill 157. This is the sort of confusion that hopefully, the adoption of regulations should try to avoid.
No, I agree. And I'm not going to beat a dead horse, but it's like, this is why it's so important for an agency that it's as young as us to have internal regulations so that you can change regulations, all the time to fine tune it. But now that we're basically, we've got the APA and we have to, deal with that. It just throws a wrench in that whole thing and makes everything so complicated and convoluted and long. But we're going to work through it, right?
Amanda Connor for the record, to kind of jump on what Lake was saying. I do understand the 20-gram sample was workshopped, discussed, but all of those workshops occurred before the legislative session and the change in lot sizes. I do think with Lake that just in talking to my clients and others in the industry, there would be a lot of confusion if we change the sample size today based on stuff that was workshopped before the legislative session when the legislature gave forth new guidance.
Thank you.
Can I ask back one question? It is so confusing because I did not understand what was happening until just this very moment. With the sample size, what would be the repercussions procedurally if a motion was made to adopt the regulations that aren't being withdrawn and amend the 20 back to the 10 while that's being handled? Would that necessitate additional procedural steps like that, I wouldn't.
It's substantiative.
Do you consider that a substantive change?
Yes.
And then in that case, everything has to go back to the LCB, but is it going back to the LCB anyway?
If it's a sub.
Or it has to be workshopped again?
Workshops, right? And-
But it is gonna be workshopped.
Right.
It is gonna be workshop.
It will be through SB 157 changes. This that we're listening to today is not intended to be workshopped again. It's already been workshopped and approved, and we're just today approving the changes that LCB has made. Additionally, didn't SB 157 make the minimum sample size 20? So it wouldn't be out of line.
It had made minimum sample size. I think one of the minimum sample sizes was 10, but that was minimum. We, as a group, again, last year during 4 different workshops and a solicitation input, agreed to increase that to at least 20 grams. And I was just stressed that if we wait until the 157, again, you know how long this has already taken to get to this point. We still probably have another 8 months to a year before these get approved. If we rely just on the 157, there's probably another 2 years down the line before we see that actually happen. And that's quick.
So if you changed it back to, Chief Cronkite for the record, if you were to change it back to 10, under LCB's opinion, that would be a substantive change, which would re-trigger workshop and start the process over basically, right?
Would you just have to workshop that provision or everything?
I think that's how you go on.
Okay, so you could limit it to that provision.
Any additional comment? Comment in the north?
No comments in the north.
Okay. All right, so at this time, let's take a short break. I do want to talk to council on process, and then we'll come back and deliberate and take a vote. Okay, so let's just do like 5 minutes. Give everybody a chance to.
It's a whole thing.
We're gonna go back on the record.
Whistle?
Morning, we're gonna go back on the record. We're talking about item 8 on today's agenda. And having listened to public comment, which is always very helpful, and staff, which is always very helpful. And this is what I'm seeing. But I'm here just today. So, okay, so this is what I'm seeing, but I'm gonna make a motion, and of course, you guys can amend the motion, you can vote against the motion, I want everybody to, this is a little bit unorthodox, but I want everybody to comment, come up here and comment and say what you feel. And staff, please tell me or tell us why or why not we shouldn't do it this way. Just so that we can have everything on the record. And this is super confusing because we've got these 2 tracks going on, but at the end, something will happen and they shall meet. Okay, so I'll make a motion. And my motion is to postpone to a future date. I know on here it says maybe January 2026, but I moved to postpone to a future date for a board meeting. And that would be on our agenda, all of Regulation 11, because this is where I've heard from everybody, the problematic areas are 61, 63, 65, 66, 68, 71, 72. And so Regulation 11 basically encompasses all that. Again, this is just my motion. It can be amended, it can be rejected, it can be voted against. But I just want to hear everybody's comments. And then, and again, this is for these regulations that we worked off of and workshop the heck out of it and sent it up to LCB. And this is all in 2024. And now we're starting the process of everything that's happened since. So that's going to be a whole other track, but it's all to come to the conclusion of getting these things in a good working order. So with that, that's my motion. And, if it gets a second grade, if it doesn't, then somebody else can make a new motion.
Member Barry will second.
Member Mazarano seconds.
We have a first and a couple seconds. Any discussion on the motion? And this is where it all happens. And I'll ask our DAG on this. So we have a motion, it's been seconded, and we're having discussion, but during this piece, we can have a conversation with staff, correct? And we can have a conversation with the public and then bring it back to the board for a vote. Okay. So where do we want to start? Do we want to start with staff? Do we want to start with public comment? Well, go ahead, public comment, yeah. Thank you. Good.
Amanda Connor for the record. I believe, and I welcome feedback on this, but I believe if you're holding all of section I, you should also hold under agenda item 8A, number 8, the definition of lot in CCR 1.125, because on the same token, that it's related to SB 157.
Unfortunately, I think the lot got put in there accidentally. There's no change to lot in these regs.
I was going
Lot is
to not
change.
fit in the thing, but can we clarify that on the record?
There's no change to lot. The lot size is going to be changed in the future workshops in December. They're not being changed in. Any vote today won't affect the lot size.
Being changed, it's not in the materials as changed.
Yeah, no, because it's a whole different track.
Yeah. But it is listed. That's the problem.
It is.
It won't affect anything.
Today's agenda as you guys changing it. So I would want to clarify that.
But there is no, lot isn't in the changes, so it will not be changed.
Okay, so for the record, lot changes and isn't going to be on this agenda.
Correct.
Lot sizes is not being affected today.
Correct.
Okay. Great. Anybody else? Comments? Concerns? Questions? Yeah, comments, questions, concerns?
I do, Tony Grassi, just
Legal?
your last statement, lot sizes is not on the agenda. What you mean is lot definition is not on the agenda.
Okay.
.125.
Correct.
Thank you. Clarification, lot sizes definition is not on today's.
Lot definition.
Okay. Lot definition. Okay, it's not being considered today, even though it's listed on there. Okay. Comments? Questions? Concerns?
Make a last plea.
Chair Cronkite, for the record, I won't make a plea. I would just like to point out that there is a lot of information and revisions that were worked on with industry, with the board for at least months, maybe
For 6 months.
longer. And there are a lot of changes in here that are very good, that would be a huge benefit to the industry. For example, there is a new testing category for things that are destined to go to production that have very limited testing. That's a huge, economic and benefit to cultivators, for example. It's a whole new testing category for laboratories as well. It will speed up the process of things going to market. There's several changes throughout NCCR 11 that have benefits to the industry, and I think it would be ideal to get those through without spending much more time reviewing them over and over, even because we already did so.
So let me ask you this, would we not be able to take that language and lift that language and put it into these regs that we're trying to workshop right now?
I think that would be a substantive change, but I'll let.
To answer your question, yes, you can put that language in the workshop right now track. You could do that.
And what's the downside? Because it's still going to get to LCB.
This is maybe not a downside, but the downside would be it's now on that later track than on the earlier track, the 2024 track.
So are we assuming that it's going to be a later track? Because the rest of them are going to go to LCB. Oh, they're going to go to the Legislative Commission once the session is over. They're going to go to the Legislative Commission. They're going to approve the rest except for 11. And then 11, we're going to workshop along with all the 2025 changes.
So there's two options the way I see it. You could either, if you take out 11, there's two options, right? You track them with the 2025 changes, or you track them on their own because they have already been workshopped, they have already been commented on. So they could stay on a separate track and you deal with them separately, or alternatively, you could deal with them all together. Those are the two options the board could take if that action happens.
But 11, since it's already 11, if it goes by itself, if you workshop it by itself, it goes back up to LCB, then massage it again, goes back to staff, you massage it again, it goes back to LCB, blah, blah, blah. Then it comes here for adoption to the board for ratification. And then it goes to LCB. And I'm just talking this out loud. But then these good changes that Chief Concrete's talking about, these good changes, if you were to put them into these the new reg workshop, I mean, then those, I mean, you just need what, 2 workshops and then it goes to LCB?
That's being a little optimistic.
Yeah. Plus, it would have to come back to the board with any substantive changes. So Chair, Jimmy Hum for the record. So Chair, I think the concern is we don't want to lose the good items out of 11 for at the sacrifice of the things that we've acknowledged we needed to look at more with industry. So the sections that you had previously pulled, we don't want to necessarily lose the other sections that we believe have been vetted, have been workshopped, aren't disputed. So if we pull all of 11, that would be the concern. And we'd have to also look at cascading effects within the other ones that you approved today.
So those good items on there, do we have members of the industry that are here that can say, yeah, don't keep those. Don't take those away because that's what we want.
Main lab spokesman is in the Supreme Court right now.
Oh, that's right.
Yeah, and at Lake Martin Nevada Cannabis Association, we would support your motion to hold off on all of Reg 11. And I think the fact that there are good things on there makes us incented to move expeditiously to workshop and come to resolution with that. But I think it could be challenging if we're sitting here right now trying to go section by section and saying what's good and what's bad, because there's going to be disagreement about what's good and what's bad and to who and to who's here in the room that can comment on that. So it makes more sense to just hold all of Rec 11 because we know about half of it has issues, or concerns, and then work on it as quickly as possible. So that's my comment.
Is it possible to rule 11 and then send it all up for approval to LCD after we've discussed it?
Put it on the record, Kara, speak up.
Sorry, Kara Cronkite for the record. I would like to ask legal if it's possible to postpone the approval of the changes to NCCR 11 and still hear that at the January board meeting as we had discussed for those specific sections, but just for all of 11, and then send that all back up to LCB for final adoption once if everyone's good with the minor revisions that aren't substantive, rather than hosting official workshops and starting the process over again for NCCR 11.
Yes, if that's how they could vote.
Okay.
Sure. If she sets a time, 60-day delay and bring it back in 60 days, you'll have to renotice and resolicit public comment and all that stuff, but you could set it for 60 days if that's how you vote, sure.
One more question. And I don't know if LCB will be on board.
Substantive change.
No.
It's a non-substantive change that is a matter of explanatory detail that you're going to talk through, not going to go back and have it reapproved by LCB. If you decide to modify language.
Allison, I'm sorry, can you come up here? I want to make sure it's on the record. Because I don't know if the recording picks up.
Sorry, for the record, Allison Herr from the Nevada Attorney General's office. Your key issue with 11 is going to be how substantive your changes are. If they are non-substantive changes, so it's a matter of needing to sit at the table and have a question and answer question like you've done partially today. Those things are not substantive changes. Those are just explanations that you're giving. They do not require LCB approval. If you're going to modify language in a substantive way and make changes to the substance of the regs, those have to get reapproved by LCB before you can move forward. There's no way to know at this point how much change that's going to require in the next 60 days. So your options basically are you can postpone for 60 days to give a chance at that 60-day hearing. You can then still decide to either reject or approve those hearings. You can, at that point, decide to reject them and send them back for workshop. You could decide to approve them as is, regardless of objections. Or you have the option today to do those same things now, or you can push it off for 60 days. It's kind of your option where you're looking at.
Okay.
My question's gonna be a little different. What if we agree to reject all of the LCB's changes in Reg 11 and resubmit it the way we did it initially? That is the big part of the problem here, is LCB's changes. So what if we just reject all of LCB's changes to Reg 11 and then approve our old ones and resubmit?
But not today.
That is.
We'd have to bring that up. We could bring that up next board meeting for the old Reg 11. But it would be everything that was already approved, in the language that was already approved by everybody, not changed, not adjusted by LCB.
I would, Tony Garossi, I would say the obvious risk to that is.
I understand.
Yeah.
Why are we approving something we already approved?
The LCB made
Changes.
Okay.
technical.
The re-vote?
Yep.
Today, what you're voting on is LCB's technical changes that were made to the version that you approved in 2024.
Correct. And the biggest problem with that was that list in 61 that caused confusion for everybody. So if we just get rid of that list and go back to the way it was.
Okay.
But that's just another idea.
Any additional questions, concerns? Amendments to the motion? I do want to make an amendment to my motion. And then who seconded okay. So my motion would be to postpone for 60 days. For 2 meetings. I move to postpone the sections, again, 61 through 73 for 60 days. Member Barry, do you accept my amendment?
Very second.
Okay.
Chair, for the record, that's all of 8I, correct?
Oh, yes, I'm sorry. That's regulation 11, item I on our agenda.
Second.
Thank you. Okay, so we have a motion on the table. Any discussion on the amendment, on the amended motion?
I would just say, I do appreciate everybody's work. I know it's so cheesy, but like the industry and staff is going through so much, and I know the process makes it hard on you, and I really appreciate that everybody worked so well. And we'll continue to.
Thank you for comments. Thank you. I think it's good.
Member Mazeron, just to clarify, when you say 60 days, you mean to the January meeting, correct?
Correct. I mean, but there could be, we could have a special meeting. I mean, so that's why I'm just saying 60 days, just in case. I don't want to just nail us down to January meeting in case there's any changes. 60 days, yeah. That way, I mean, we've waited this long. We've been working with, what's another 60 days? I know it's a lot, but.
Yeah, you'll come back for that.
Special appearance, no. Okay. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Okay, and now we go on to the rest of the regulations, other than regulation 11. Is there any discussion from staff with regard to the rest of the regulations on our agenda? Okay, public comment with regard to any additional from what you've already stated? Anybody up north?
There's no comment in the north.
Okay. All right, well, with that, then I'll take a motion on the rest of the regulations on our agenda being A through L minus 11, or minus I, which was regulation 11, which we just voted on. So the rest of them.
Member Barry, I'll offer motion to accept all of the regulations A through L with the exception of I on the agenda.
Throw on a second step.
Thank you. We have a first, we have a second. Any discussion on the motion? Hearing none. All those in favor say aye. Aye.
Aye.
Any opposed? Motion carries. All right. Good job, everyone. And now we have the briefing from the chair and the executive director. Again, I reiterate my comments from the beginning. Thank you so much, everybody. And I am gonna miss this. So thanks for making it great for me. Executive Director Hom.
Thank you, Chair. Not for leaving, of course, but thank you.
Are you sure about that?
Another riveting couple hours of administrative procedure. I'd certainly kid, though. That comes with a huge thank you to the entire CCB team. These aren't easy to set up with these workshops. Again, we have been working on these since my second month on the job, which would be January of 2024. Also want to say thank you to industry. We always champion transparency here. So we appreciate this, the open dialogue, everyone coming up, receptiveness to discuss and work both ways, which I found to be fantastic over the last 2 years and especially during this process. So we will continue that. To Deputy Director Miles' point, please, please, please join us on December 2nd and 4th and what I expect to be also subsequent meetings at board and workshops. Again, thank you, but apologies to the team because those will still be coming. Again, thank you to industry. Chair, it has been an honor to work with you, truly. Again, I'm trying not to get sad, but I have the last few meetings because everyone is leaving me. So we have Bailey, Rath, and now, of course, last but certainly not least, Chair Guzman Freilich. Again, I cannot thank you enough for all of the hard work, all of the phone calls, all of the challenges we've been able to overcome together and for setting the table for us to overcome even more. So what is funny, though, is you said something earlier, I'm here just for today. That could not be further from the truth. What you've done here for the board has been nothing short of remarkable. So you will continue to be with us in all of your fantastic decisions and all of your leadership and what you've provided to this board moving forward. To everyone else, if there's one constant I've found in cannabis, it's that everything is always changing. So again, with that foundation that you and past chair and the former chairs, we have that foundation. We have that team with Rachel Branner stepping up to be the chief. So I'm not happy that you're leaving. I'm ecstatic for you, though. But just again, to you, a thank you. To the industry. We will figure it out. So thank you again for working with us. And we also have a plaque for you, Chair, that I will pass along to you after this. But again, I could not thank you enough for everything and for your leadership. So that is all I have. Again, thank you to industry. We will continue with the change. We will continue to make it work, and hopefully we'll continue to work together. So thank you all. Chair, specific thank you to you. We wish you best of luck.
Thanks. And with that, our next meeting. I'm bad about that, or but I guess I better get used to it, right? Gotta change that. Okay, so the next meeting is December 18th, 2025. And then any items for future agendas for discussion only from board member? No. Okay. Last public comment.
Since they just first, I think it'd be good to get an update. Just kind of the process is moving along and the meetings are occurring. I think it'll be good to
What's
hear
going to
that.
happen at this next meeting
Or
for future agendas?
yes, just get an update. It's moving along, and so we don't kind of run into this roadblock maybe next time. Look to see that, just an update on the agenda. And since we didn't get a chance to talk, I just want to echo that it is to highlight working with you and serving with you, and thank you. And you're on the bigger and better things, and I know that. And I'm just going to put that out there.
Thank you. Likewise. Yep. So as far
Real quick, yes, for update items for future agenda, General, you would like an update on a status check, basically on where we're at in this process.
Perfect. Okay.
Oh, that's a good idea.
Yeah.
Yeah. Okay, we'll go on to our last public comment. Any public comment?
Can I say my goodbyes?
Yeah.
Well, flowery speech because I think we became friends and I will, I don't consider it a goodbye at all. So thank you for what you did. Thank you for your leadership. I've certainly learned from you and we're in great hands now. I feel like with Jimmy and the work that you did to really create a very nice culture and really great collaboration. I really appreciate everything I've learned from you, but it's not goodbye. So that's all you get.
I second that.
You get.
Okay, thanks, guys. Any additional public comment from the members down here? Members of the public? Okay, no, how about Reno?
There's no comment in Reno.
Is there anybody in Reno? Reno always gets left out.
Yeah, they all left after their presentations.
Thank you. Thank you for sticking around. No. All right, so with that, we're gonna adjourn. Thank you all.